Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Samuel Oliveira, and this is the sixth panel of the fourth day of the event. In the name of the ICAIL organization, I'd like to thank our platinum sponsors, Jus Brasil and Albert Einstein Israeli Hospital, our gold sponsors, Logarithm, Legal Code, and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Opsi Lawyers, and Oasis Open. Now, I'd like to introduce Mr. Malte Ossendorf. Mr. Ossendorf presented earlier today the full paper with the title, Evaluating Document Representations for Content-Based Legal Literature Recommendations, which will now be streamed. Afterwards, we'll have 10 minutes for questions and discussion.
Thank you. Malte Ossendorf, and I'm presenting our paper, Evaluating Document Representations for Content-Based Legal Literature Recommendations. And this is a joint work with Elliot Ash, Terry Ruers, Bela Gibb, Julia Moreno-Schneider, and Georg. In this research, we explore how state-of-the-art document representation techniques perform in the context of a legal document recommender system. So why did we conduct this research? Literature recommender systems help legal professionals to find relevant literature, and they are getting more and more important as more and more literature is getting available. And in the recent year, there have been much progress in the technologies that underpin recommender systems, mostly based on deep learning approaches like transformer models or graph embeddings. So the question is whether these improvements are also beneficial in the context of a legal recommender system. Besides the technical aspect, we conduct this research also with reproducibility in mind. In general, recommender system research is known to have a reproducibility issue. And this issue also exists for legal recommender systems, where evaluations are often based on a small-scale user study, and also the evaluation data is rarely published. And this leads to inconsistent research results and makes it very difficult to actually reproduce the research. And that's why we set ourselves the following two research objectives. First, we want to evaluate a large variety of state-of-the-art methods. And second, we want to use publicly available data sets so we can make our work reproducible. This brings us to the data sets that we use in our experiments. We have three main criteria for the data set. That is an open license that allows us to share the data without any restrictions. And the data set should be also sufficiently large and also reflect different information needs. The large coverage of the data set is especially important when we want to compare fundamentally different methods like text-based against citation-based methods. We found two resources that fulfill these criteria, namely that is Open Casebooks and Wikisource. Open Casebooks is a platform from the Harvard Law School library where users can create and share open license casebooks. Their corpus consists of around 200 casebooks containing 3,000 cases. And the casebooks cover broad topics, but also rather specific ones. The cases from Open Casebooks are linked to the Case Law Access project. So based on this, we can retrieve full text and also the citation data for all the cases. After some cleaning procedure, we end up with relevance annotations for 1,601 court decisions for this data set. Our second data set is Wikisource. Here we utilize a collection of around 3,000 US Supreme Court decisions from Wikisource. Wikisource is a project like Wikipedia from the Wikimedia Foundations, and they collect original source documents. And this collection we are looking at is a collection of court decisions that is categorized in 67 topics, rather broad topics like antitrust or civil rights. A source for the full text and citations we map the court decisions to the court listener corpus to have all the data available. And here, as a result, we have relevance annotation for 1,363 court decisions. But how do we derive relevance annotations from these data sets? In our experiments, we are considering a recommender scenario where we have a seed document and we want to know which other document would be a relevant recommendation for the seed. So as ground truth data, we need pairs of documents that are relevant for each other. And the two data sets provide exactly this information. For example, when decision A and B are in the same casebook or in the same wiki source category, we can say that A is relevant for B and vice versa. This relevance definition is, of course, limited. For example, one recommendation still might be relevant despite not being in the same casebook or category. That's why we rather refer to these data sets as silver standards instead of gold standards. However, the advantage is that this approach produces a large number of relevance annotation for open casebooks. It's 140,000 document pairs, and for Wikisource, it's 200,000 document pairs. And this number is much larger compared to the user studies from related work. And it also enables us to evaluate a large number of methods. In total, we evaluate 41 methods and variations of them, and which 27 are actually presented in the paper. The remaining ones were excluded due to either poor performance or because they didn't provide any additional insights. The methods themselves, we distinguish them in 5 categories. First, we have a TF-IDF baseline. Second, we have word vector-based methods like paragraph vectors or document vectors from averaged word vectors from fast text or GLAF. This is also known as mean pooling of word vectors. And here we test also different variations. One is kind of the original version of GLAF or fast text trained on a generic text corpus. And also one version where we train the word vectors on our legal corpus. We also test variations with an artificial total limit to make these methods comparable to the transformer methods. As transformer methods, we have BERT, REBERTer, different sentence transformer models. We have longformer and 2 separately published legal BERT versions. One from Chakaldas et al. From the Athens University of Economics and Business, AUEB, and one from Holzenberger et al. From the Johns Hopkins University, JHU. In addition to the citation text-based methods, we have text-based methods. Oh, sorry. In addition to the text-based methods, we have citation-based methods that utilize the citation graph to derive document embeddings. And lastly, we have hybrid methods that make use of both text and citation features. There is one approach that is the concatenation of document vectors from 2 methods. And also we have the score summation of similarity scores from 2 different methods. And as another hybrid method, we have a sentence transformer model that we train with citations as training signal. Before I dive into the actual results, some more words on our evaluation methodology. We separately evaluate open casebooks and Wikisource. And each of the tested methods here produces document vectors for all documents in the corpus. And then based on the vector representations, we then perform a k-nearest neighbor search to retrieve five most similar documents, which are then used as recommendations. For the evaluation, we then compare the seed document and the recommendation candidate with our silver standards to determine whether it is a relevant recommendation or not. As a performance measure, here we have precision, recall, mean reciprocal rank, and our primary metric is mean average precision. Just as a side note, we set K to 5 because of the user interface where we want to deploy our recommender system. We also experiment with different K values, but found the results to be similar. All right, so let's start with the actual results. In this table, we have the tested systems, the dimension of their vector representations, and then the performance metrics for open casebooks and Wikisource. And we have the rank that's based on the average MAP over the two data sets. And this is also how the rows are ordered in this table. And also in this presentation, I will now only show parts of the actual table. So please look into our paper for the full version of it. On average, we have the hybrid score summation of fast text legal. So that's the fast text word vectors trained on our corpus, and the citation graph embeddings from point care, and they together have the highest MAP score. But if we view the data set separately, we have a slightly different outcome for open casebooks. It is the text-only method fast text legal that yields the highest MAP, whereas for Wikisource, it's another hybrid method, the concatenation of fast text legal and point care that yields the highest MAP. The other domain-specific word vectors like paragraph vectors or glove legal are also among the top methods. On the lower end of our table, we have the worst performing methods, which are sentence transformer models like Sentence Roberta or the citation method BoostNE. Now, for more insights, let's look at the method categories separately. Here in this table, we see all the word vector-based methods that we evaluated. At the top, again, we have the domain-specific word vectors that utilize the full article text. We see that also limiting the document text to a length that can be processed by the transformers does harm the performance, as we can see here with fast text legal limited to either 4096 tokens or to 512 tokens. The other domain-specific methods like paragraph vectors or glove legal have shown a similar decline when limiting their document length, but are not listed here in the paper. But more important than the token limit is the in-domain pre-training of the underlying word vectors. As we can see here with the original glove and fast text, those kind of generic word vectors were trained on Wikipedia or news text, so nothing was legal. As third category, we have our transformer models. And yeah, despite being very successful for many NLP tasks, one major weakness of transformers is that they are made to process relatively short text. So for example, in BERT, the limit is 512 tokens. In Longformer, it is 4096 tokens. And in our experiments, we have legal documents that are typically longer. So here we only can process the first n tokens of the documents that fit into the corresponding transformer model. And that's, of course, one limitation here of the transformer models. And to make the results comparable, at the top here, we have the legal or fast text legal version, where we have the similar limited token number. And exactly these two fast text legal variations are also on average better than all other transformer models. Whereby for open casebooks, the token limit has a stronger effect on the performance. Here we have long form or large, the best transformer model, and it also outperforms the 512 token version of fast text legal. For the other data set, for Wikisource, the token limit is less critical. Instead, the in-domain pre-training has a greater effect. So here we have the two legal BERT versions are the best transformer models. And generally, we found that from the two legal BERT versions, the one from AOEB outperforms the one from JHU. And we see this reason for this outcome in a larger and more diverse pre-training corpus that was used from the one from AOEB. Similarly, we see that among all transformer models, the large version outperformed the base version. For example, here, Longformer or BERT. But yeah, overall, the performance of the transformers is relatively low. But one could expect that there might be a performance gain when, for example, you would train a Longformer model on a legal corpora. Yet these potential performance gains will most likely not justify the computational effort, in particular when we already have very simple and yet effective methods like averaging word vectors. And this is also what we found when we analyzed how the performance changes depending on the length of the seed documents. And there we found that even for short documents, fast text legal outperformed all the transformer models. In addition to the text-based approaches, we also evaluate citation graph embeddings. And in this category, we have a SPAT method, point care, closely followed by walklets. And overall here, we found that there's a strong dependency on the availability of citations. And that's why we say, or we suggest that these citation methods are actually better combined with text-based methods. And this is exactly also what our evaluation of the hybrid methods show. Here as hybrid methods, we focus on the combination of the previous best single methods, which are fast text legal and point care. Other combinations like glove and walklets have shown a similar performance, but they're excluded because they didn't provide any additional insights. The best methods in this category are also the best methods overall, and that is the score summation of fast text legal and point care. And again, here we also see a difference between the performance of open casebooks and Wikisource. While for open casebooks, the score summation is the best hybrid methods. For Wikisource, it is the concatenation of fast text legal and point care. Other combinations, especially the one from two text-based methods, like here fast text legal with Longformer, do not lead to the same performance gains as the combination of text and citation-based methods. And why the combination of text and citation improved the results is clear when we now have a look at the similarity of the recommendation sets. In this heat map, you can see the Jacquard similarity of the recommendations of two methods, where Jacquard similarity of 1 means that all recommendations are identical, and 0 means no overlapping recommendations. And what you can see here is a higher similarity between the text-based methods and also between the citation-based methods. But when you compare the similarity between text or word vector methods and citation methods, the similarity is low. So this means that they produce a different kind of recommendations. And this is also why combining them in a hybrid manner leads to this performance improvement. All right, so what conclusions can we draw from our experiments? First of all, document vectors from averaged word vectors achieved surprisingly the best results for all single methods. In particular, fast text word vectors trained on our legal corpus performed the best on both data sets. The training of such word vectors does also not require any special hardware like GPUs. And even when we introduced this artificial token limit, the performance of fast-text legal was still comparable high. On the contrary, we have the performance from the transformer model that were rather disappointing. Of course, we have the weakness of the token limit, which is especially a problem when we have lengthy documents like these court decisions. And of course, there are promising research efforts like the long former that are capable of processing more tokens. However, right now, training such a model and especially applying it in a production environment requires much more compute resources. And these potential performance gains do not really justify these efforts. Much less effort actually does it take to combine text and citation methods in a hybrid manner. In our experiments, we use very simple approaches like the concatenation of vectors or just adding up similarity scores, and still outperformed all other single methods. Lastly, we also validated our quantitative findings based on the two silver standards with a domain expert who agreed in 70% with our silver standards. And this high agreement and also the large quantity of the two data sets makes them very interesting for future work, where we plan to use them to benchmark also new different document representation methods. All right, thank you very much. Please feel welcome to look at our code and dataset. It's all available on GitHub.
Thank you, Mr. Ossendorf, for your presence here tonight, and congratulations on your work and your great presentation. I have a first question by Marcelo Lopez, and it's the following question. Is there any special reason why you chose open casebook and weak source as sources for the documents? I noticed that many methods work better on one source than another. Why do you think this happened?
Thank you for the question. So first of all, we mainly choose these two data sets, not really because of their documents, but rather because of their relevance annotations. So we could use them actually to evaluate the methods because they had kind of this topic assignments or those casebook assignments. That was kind of the main reason for us to use these two data sets. And then regarding that we have on Wikisource kind of better scores. And this is due to, I think, two things I would say. One is that Wikisource is only about US Supreme Court decisions, where they also cover relatively broad topics, right? It's kind of a special type of documents, and there's not too much diversity in those documents. And this is the other reason, it's probably now more important, is that kind of on average, we have for each C document more relevant annotations in Wikisource than in open casebooks. So just in theory, there are more potentially relevant recommendations. And this is why we see this outcome.
Thank you, Mr. Ossendorf. I have another question, and it's the following. In your paper, the documents evaluated were legal documents, such as court decisions. If we were to adapt the system to work on education and scholarly literature, what changes would be necessary?
Yeah, thank you again. Basically nothing. So the methods that we used are kind of used in an unsupervised or zero-shot setting. So we don't actually train the models on our evaluation data. So if you now just want to apply these methods on a new corpus, you just need to have basically the text input, and then can derive based from the method or based on the methods your document vectors, and then kind of perform your similarity search on these vectors. So the input is basically text, and yeah, the output are these vectors. So you don't need to do anything else. Well, of course, kind of if you want to evaluate this on a different corpus, which probably makes sense before you want to apply it, then you of course need to have some kind of additional data to measure how good the methods are on your data set.
All right, thank you, Mr. Ostendorf. Is there any further point you'd like to address or any comments you'd like to make?
Just a part of thanking you for this opportunity to present the paper here. Yeah, nothing. So thanks again.
Thank you very much. So moving on, I'd like now to introduce Mr. Jaromír Savelka and Mr. Hans Westermann. Yesterday, Mr. Savelka and Mr. Westermann presented the paper with the title Lex Rosetta, Transfer of Predictive Models Across Languages, Jurisdictions, and Legal Domains, which will now be streamed. Afterwards, we'll have 10 minutes for questions and discussion.
Welcome, everyone, to the presentation of Lex Rosetta, which is a work on transferring predictive models among different contexts, such as languages, jurisdictions, and legal domains. As you can see, this work is a joint effort of a sizable team of researchers in machine learning, computer science, and law, coming from many different institutions. And as I already said, this presentation will be delivered by Hannes and myself. So in this work, we investigate the task of segmenting adjudicatory decisions into parts, such as the background of the case, the analysis, or its outcome. We specifically identify the task that is general and fits different contexts. By that, I mean different types of decisions from different legal domains, even countries and legal systems, which also means the decisions can be in different languages. We use this task to evaluate the effectiveness of pre-trained multilingual embeddings to transfer a trained machine learning model across such contexts. We release the task type schema definition, the annotated dataset, as well as all the code we used in our experiments to the public.
So why are we doing this? Well, I think what you often see in machine learning is that the model is trained and evaluated on data with the same distribution. So there's some data set that is assembled, such as from legal cases, often, for example, from the same jurisdiction or in the same language. This is then split into a training and a test portion. The training portion is used to train the model, and the testing portion is used to evaluate the performance of the model. But this doesn't always tell us about how well the model will generalize. What happens if we give it a new unseen data set? Because the model might have learned some specific particularity of the data set it was trained on that will still work well when applied against this testing model, testing data set, but when it is used in practice, perhaps the data looks different and the model might just work very badly on this new data. So here we investigate whether it is possible to build models that generalize between different contexts. And as Jeremy mentioned, by context we mean different languages, different jurisdictions, and different legal domains. So we identify the task that is relevant across many such contexts. And the task that we chose was to segment legal decisions into different portions. First, the segment of the background, where the facts are introduced. Then the analysis, where a judge would discuss these facts and apply legal rules. And finally, the outcome, where it states the results of this. And here you can see a human annotated decision from the Czech Republic that has been annotated with these segments. But this kind of type schema works across many different contexts. So here, for example, is a decision of employment dispute from the United States that has also been annotated by a human with these same categories. So what we can do now is that we can take data from one context, train a model with this, and then evaluate how well it performs on data from another context. So for example, what we've done here is that we've taken a model that is trained exclusively on data from the Czech Republic. And then we've used that model to segment this decision from the United States. And here you see the results of this. So this is purely generated by a machine, these segments, that has never before seen any decision in English, and has never before seen a decision in labor law, but rather has been trained on decisions from the Czech Republic from various different courts. And as you can see, it still works pretty well. And I think this is pretty remarkable. What we're really doing here is that we train a model on data from the Czech Republic, and then we evaluate it against data from the United States that is never seen before, fully unseen data. But despite this, we achieve a weighted F1 score of 0.86. So that is one of the things we evaluate here. But we also look at what happens if we pool multiple such data sets together. So what if we add additional context to data from the Czech Republic and evaluate that against data from the United States? And what happens if we use all of our data set as a pool for training? Will that and include also data from the target context, so the United States in this case, will that further improve performance? I think this could have pretty interesting implications here. First, it could allow the creation of really robust and generalizable models. That is, models that you could deploy in a real world scenario, and it would work across many data from with different distributions, different languages, and from different contexts. It could also allow the rapid adaptation of models to new contexts. You could start with a model that has already been trained and that works pretty well on your target context, and then fine-tune it a bit to make it work really well. That's probably much quicker than training it from scratch. And finally, it enables this international collaboration of researchers, since researchers can annotate their own data set and contribute to a common pool that is then useful to all the different researchers across many different countries.
All right, let us speak about the data set. So as already mentioned, the first step in creating the data set was a definition of the type schema. This definition is expressed in detailed annotation guidelines, and of course, these are also available in the project repository. The type schema includes types such as out of scope. So these are parts outside of the main document body. For example, metadata and editorial content, maybe endnotes, appendices, and such. Also headings. These are fairly straightforward. So for the purposes of our experiments here, we removed the out-of-scope content and headings, which only left us with background, analysis, and outcome. Background is the part where the court describes procedural history, relevant facts of the case, and so on. Analysis is the section that contains reasoning of the court, issue, maybe applicable law, and finally, outcome are the few sentences stating how the case was decided. It is worth mentioning that by removing headings from the texts, we have made this task more difficult. Right? There are some domains where headings are suggestive about the beginning of a certain part. However, this is not a general rule. And what we wanted to do is to make sure that the models we train will focus on the meaning of the text rather than on superficial cues, such as the presence of a heading. Reliance on such cues would have almost certainly resulted in models that are very brittle and would prevent a successful transfer among different contexts. Now, after learning the types definition and participating in the training, the authors split into 8 teams, where the goal of each team was to assemble a dataset of approximately 100 documents. The authors could create such dataset in whatever way they wanted. The only constraint really was that each sub-dataset needs to contain decision documents that are in the same language. The aim was to obtain collections of documents that would be quite different when compared to each other. We needed this in order to investigate the transfer capabilities of the multilingual embeddings. To give you a more precise idea of the differences among those subsets, let us look at some of them more closely. First of all, it's apparent that they come from different countries and the documents are very often written in different languages. For example, The German subset is a stratified sample from the federal jurisprudence database, spanning all federal courts, such as civil, criminal, labor, administrative, and many more types of court. On the other hand, one of the USA subsets is a very specialized selection of federal district court decisions in employment law, mentioning the term motion for summary judgment, employee, and independent contractor. So a very, very narrowly specified domain. Overall, the dataset consists of 807 cases coming from 7 different countries that are written in 6 different languages. There are almost 90,000 sentences annotated with one of the types from the schema presented earlier. As already mentioned, the dataset, including the type schema definition, is available in a publicly accessible repository. To give you a bit more insight into the data we operate on in this work, let us look at this graph. First of all, notice that we did not use the out of scope and heading sentences in our experiments here. This reduces the size of the dataset from around 90,000 sentences to roughly 75,000. It is very apparent that there are some considerable differences among the parts of the dataset. For example, the French decisions are quite short when compared to others. But there are also some shared similarities. For all the datasets, it holds that the analysis sentences are the most numerous, followed by the background sentences. Finally, the outcome sentences are the most rare. Except the French subset, the number of outcome sentences is considerably lower than the number of sentences of the other 2 types. That is for the dataset, and let us move on to the models.
Right, so to perform this task of segmenting the decisions into different sections, we need to develop a machine learning model. And this is a high-level overview of how that model looks. So at the bottom here, you see the case that is, first of all, split into different sentences. And each of these sentences using tools such as Spacie. And each of these sentences is then fed through an embedding model that is called LASER, language agnostic sentence representations, that embeds these sentences into an embedding space, a vector of 1024 dimensions. And the special thing about this representation is that it is language agnostic. So these embeddings, if the semantic content of the sentence is similar, they will be in a similar embedding space, close to each other, no matter the language. This is then fed to a gated recurrent unit bidirectional network, that then for each sentence outputs a label, such as the background, the analysis, and the outcome. And this is a bidirectional model. So in making these predictions, this model has access to the previous and also the following sentences and their embeddings. So then performed a number of experiments. We evaluated 3 different hypotheses, and what they differ in is what is used as training data, whether it is single or multiple data sets. And we always compare them against a baseline to make sure that the results are strong. And then we evaluate this by looking at an F1 score, and we do this, that is a harmonic mean between precision and recall. And we do this for 10 k-fold splits for each experiment to make sure that the results are regular. So let's start with the first hypothesis, that is the out-context experiment. So the question that we want to examine here is, can a model trained in a single context generalize to other contexts? So it's possible that a model can learn from one language or jurisdiction and so on, and be successfully applied in another context. So we saw this before, where we use one single context as training data, and then we test it against another context. And we move through the different contexts this way. First Czech Republic, and then France, and so on. And once we've done all of these, we will use a different context for training, such as the Czech Republic, and test this against another data set. And we compare this against a baseline of stratified random prediction, and that outputs a random prediction based on the distribution of the data. And here you can see the results. So to the left here is the context this is trained on, and to the right is the average F1 score, and we compare it against the rest of the data sets. So the baseline gets an F1 score of about 0.51. And all of our models actually gain an F1 score that's quite higher than this, between 0.60 and 0.70. and sometimes higher. So this seems to be able to learn something. And we've also seen that if data sets are similar, it seems to perform better, such as Canada and the United States. And we'll get back to this later, why this might be the case. And even the outcome section, that is much rarer than the other sections, is sometimes works to predict using this model. So from this, I think we can take away that the models are able to transfer knowledge between different contexts, despite having never seen this before and being completely different languages or domains. So next, let's look at the H2 experiment, the pooled out context experiment. So here, the question is, what if we add additional context to the training pool? Does this increase robustness? As in, does it make the performance better when applied on unseen data sets? So whereas before, we use a single context for training and tried it against a target data set. Now we use this single context plus the other contexts that are not part of, that are not the target data set, and see how well this model performs. And then we move on. So for example, here we take France and then we exclude this from the training data and continue prediction. And as a baseline here, we use the best performing out context model per context. And I want to highlight that this is quite a competitive baseline, since as I mentioned before, some data sets are much closer together. For example, Canada and the United States perform very well across each other. And that means, of course, that if a model is trained on Canada, this will be the best performing out context model per context for the United States. Whereas our model has many more different data sets that it needs to abstract from and learn this to apply to this new context. And here you can see the results. So this row is for the baseline, and here we have our model. And as you can see, in 7 out of 8 cases, our model matches or improves on this baseline. And the results, as you can see, are pretty high, usually over 0.80 and sometimes even over 0.90. And remember, this is on really unseen data. So this is something that could potentially be useful when applied in practice and being used in a completely previously unseen domain. So I think from this we can take away that training on a pool of data sets leads to more robust models, and it leads to better adaptation to unseen contexts. And finally, we have the pooled within context experiment. So what's happening here, that the question is, does combining in-context data with out-context data improve performance? So whereas before we excluded this training data, now we add this data as well. So we use all the different contexts for training and then evaluate it against a single test context. Of course, we don't use the same data. We use different folds here so that it's still never seen the testing data, but it has seen data from that context. And then we move through to use this to predict the different target contexts. And as baseline here, we use in-context models. And so that is a model that has only been trained on the target context. And again, I want to highlight that this is a super competitive baseline. This is seeing the data that will be by far the most similar to the target context. And this means that the model trained on only this data should have a really good opportunity to learn the distribution there and to do that prediction. Whereas our model, of course, has 8 different data sets that it needs to learn from and extract from. So it is quite difficult to get this baseline. But despite this, in 6 out of 8 cases, our model outperforms this baseline. And again, the results are very high, often over 0.80 and often even over 0.90. So I think from this, we can take away that training on in-context data pooled with out-context data does improve performance when compared against this single models trained on a single target context. So the model does seem to be able somehow to abstract from these different data sets and take the lessons to build a stronger model.
All right, let us look at some of the findings more closely. So the results from testing hypothesis 1 and hypothesis 2 strongly suggest that multilingual embeddings focus on the semantics of the sentences rather than superficial linguistic features. This is extremely important for a work like this one. It is very important that the models focus on the semantics and avoid fitting the context-specific idiosyncrasies, even though they could be useful within that context. Moving on, we observed that some of the contexts appear to be more related amongst themselves than to other contexts. In order to get some additional insight into this phenomenon, we projected full documents into a shared semantic space. Using PCA to reduce the dimensionality to just 2, we obtained this visualization where each dot represents a single document. The color encodes membership of a document in a specific context. You can see that both the USA subsets occupy virtually the same semantic space. This makes a lot of sense if you consider that the documents are written in the same language, they come from the same tradition. On top of that, both subsets are focused on employment law. German subset occupies a space in the middle, and it also appears to be a bit more dispersed than the other ones. This is likely due to the fact that it is the most general data set, not focusing on a specific topic. Of course, this is expected, and it provides grounds for future work. In this work, we did not factor the context relatedness in our experiments at all. Another interesting observation relates to structural differences in the documents. We noticed that German and Polish models struggle in predicting the outcomes for other subsets and the other way around. This is explained by structural differences in the documents. Whereas the German and Polish documents report the outcomes that are depicted in green at the beginning of the decisions, the documents from other subsets tend to place these towards the end. However, it is promising that the models that have access to data with both these patterns were able to acquire them both and apply them rather successfully. To conclude, we observed that the models utilizing multilingual embeddings manifested good generalization capabilities. It appears that pooling multiple contexts together results in improved robustness and performance of the models, and it helps even when in-domain data is available. It was an extremely rewarding experience to identify a task that was relevant for researchers with different interests and was applicable in wildly different contexts. And we are really looking forward to what comes next and how the dataset and the code we released is going to be used by this community. And of course, we also have some ideas of our own. While the dataset is sizable, it would certainly benefit from expanding it with more documents from more different contexts. We use the data in the most straightforward way here to segment the documents into parts with different function. However, this could be a useful step in many applications focused on, for example, information retrieval or summarization. In our experiments, we simply pull the data from different contexts together. Using more sophisticated approaches would be a reasonable way how to improve on this work. Finally, we also anticipate that resources resulting from this type of work could be useful for gaining insights into differences and similarities among the different contexts, akin to the structural analysis of the documents performed here. All right, that's all from us, and we are looking forward to your questions.
Thank you very much for your presence here tonight and for your presentation yesterday, Mr. Savalkan and Mr. Westerman. For now, I have 2 questions from the audience. The first one is from Jack Conrad, and he has the following question. Could you address the difficulty of the tasks, given the trade-off between more general training data and the ability to the models to tackle more difficult tasks? Is this a sacrifice you wish to make?
Thank you. This is a fantastic question. So obviously there is this trade-off between, I would rather say specificity than difficulty of the task and the generality of the task, right? So in order for this type of approach being applicable, the more general task, the better, right? Because then you get the opportunity to use more context, and you don't really need to be worried too much about the specifics, right? But very often, what the researcher would be interested in might be something where they deal with a domain that just has its peculiarities, and this is what they are interested in, right? And in this case, it might not be completely appropriate to necessarily try to take this path. However, still, that task may have some general traits, and maybe they might be able to use this approach to maybe tackle parts of that task, to maybe save themselves from some data collection that they would have to do, and maybe they can just focus on the other parts that are just peculiar to that specific domain.
I also want to highlight here that in the data set that we released, there are in fact many more labels than we used here. So we also have headings, we have introductory summary for some cases, and so on. So I think even here there will be many more tasks to explore, and we're looking forward to do this, but also encourage others to look into this.
Thank you. The following question from Marta Costa is the following. Do you think your research conclusions can encourage international cooperation among researchers?
Thank you. That's another really good question. And I really think it can. So I think usually the way it works in AI and law is that researchers will build some data set that's focused on a particular domain in a particular language, which works really well for them. But of course, if others want to reproduce the research in their own domain, they might have to annotate some new cases so that it generalizes. But I think here we've devised this task that is a task that makes sense in a lot of different domains in a lot of different countries. Here we use the 8 different contexts. And then we also show that the model behind it is able to abstract away from these particular contexts and learn some general idea of this task that is domain independent. I think this is super promising for this kind of international collaboration, since the way it could work is that researchers annotate their data sets still, the one they're interested in, the one they're working on in a particular domain. But then they can also share this with other researchers. And it's a kind of win-win situation, because by sharing this data set, the other researchers can train a model that is general, and that performs better, in fact, than if they use only their own data set. And of course, the original researcher can also take the data sets from the other and add this to the model. And not just that will this make their model probably stronger, and it will also make it much more robust, meaning that you can, instead of only being able to apply this model in their own domain, they can suddenly use this model that they built and apply it to other languages and other domains, which could be really important if you want to build a model that you then share and use in the real world and apply it to different languages. So I do think that that's a very exciting aspect here. I'm really looking forward to explore that aspect.
Thank you so much. Is there any further points you'd like to address, any further comments?
Yeah, I guess that I would just really like to thank the whole team, because that is what I think is really unique about this work, that such a large team of researchers with completely different backgrounds, like from law, computer science, were able to come together and really put together this resource that is now available there for everyone. And I would really like to invite the whole community to look into that resource and start playing with that. We don't really keep anything for ourselves. We have even published, so big parts of the data sets are double annotated. So we have even published the annotations from both the annotators. So there is even potential for some sort of a research on how to deal with potentially conflicting labels and so on. So please look at it and play with it.
Thank you so much, Mr. Svelk and Mr. Vesseman. Moving on, I'd like to introduce Mr. Georg Borges. Earlier today, Mr. Borges presented the paper with the title AI Systems and Product Liability, which will now be streamed. Afterwards, we'll have 10 minutes for questions and discussion. Thank you.
And good morning or good afternoon, everybody, depending on which part of the globe you are. AI Systems and Product Liability. Did I share my screen? Not yet, I guess. I prepared some slides, which are hopefully visible now. And it's my subject, AI Systems and Product Liability. Just let me move on, just to make it clear, I'm professor of law. I'm not technician, I'm lawyer. And this presentation is on legal aspects of AI systems. So I'm not going into detail of technical aspects. It's about the law regulating the technology in this case. What is the role of liability within the legal framework for AI systems? Let me briefly introduce. AI systems give rise to enormous expectations. We think that the world will be brighter and richer once we are establishing a framework, a coexistence of humans and AI systems in some future. However, at the same moment, there are some risks associated with AI systems. And the most striking example, which made it clear to the world, maybe was the Uber car accident 2 years ago, when a self-driving car was running over and killing a pedestrian. I'm sure you're aware of that. Another aspect of risks associated with AI systems are machine-made decisions, which is often linked to the questions of algorithmic fairness or machine bias. In this case, very often a machine is making a decision which has an effect on humans. For this presentations, I will not deal with the second group. I will deal exclusively with the risk associated to physical harm and damage caused by AI systems, such as machines like self-driving cars and others. AI systems pose a very specific challenge to the legal systems, as AI system can show what I would like to refer to as behavior. Of course, any machine can function, but what is different between function and behavior? Just as a working definition, I would define behavior in this meaning as the ability to choosing actions depending on a perceived situation, which a traditional steam machine 200 years ago could not do, but or self-driving car would have to do at any moment while it's functioning. This is a challenge to the laws, as behavior or choosing action is an ability which was attributed to humans only, not to machines. And the legal system is not prepared to a machine showing its own behavior. It's not surprising that liability is in the core of the legal discussion for an adequate legal framework for AI, at least in Europe. From 2018, the European Commission was active in this field, starting, for instance, with the communication of 2018 AI for Europe, where a good deal of the paper was dedicated, surprisingly, to questions of law, in particular liability. The next, as a step, I want to refer to the work of an expert group on liability and new technologies, which was established by the European Commission in 2018 and delivered its final report in December 2019. I will refer to this as the expert group made the conclusion that some amendments of the current legal framework are needed, in particular, the introduction of new rules on liability. The European Parliament took the opportunity in October 2020 and suggested the introduction of a civil liability regime for AI systems, in particular, including a proposal for regulation on liability of operators of AI systems. And most recently, the European Commission in April 2021 published its proposal for the so-called AI Act. The AI Act is a very, as it's demonstrated by its title, a suggestion which introduces fundamental principles for the use of AI systems. By substance, however, it mainly restricts to the introduction of the duty to establish a risk management systems by operators and producers of AI systems. It does not refer to any liability rules, since these rules will be dedicated to a specific insurance for liability for AI systems. We expect the first proposal by the European Commission to be published in fall this year or spring next year. I want to talk about liability in the AI system. So what are the functions and concepts of liability? This is very important to bear in mind when we talk about the detailed questions. The traditional function of civil liability is to offer compensation for damage occurred. However, a second and possibly even more important function of civil liability is that it creates incentive to the addressee of liability to adapt his behavior, for instance, driving carefully in order not to be liable. When we talk about concepts of liability regimes, we should distinguish between the traditional fault-based liability, which is known worldwide in every jurisdiction which I'm aware of, where liability depends of the existence of a breach of a duty of care. You're only liable under fault-based liability if you breach a duty of care. As a contrasting concept is well known, the concept of strict liability, which exists in a huge number of variations. Basically, the idea of strict liability is that the addressee of liability is obliged to pay damages whenever a damage occurred within a defined sphere of risk. Just to give an example, under many jurisdictions, the operator of a car will be liable to pay damages whenever an accident occurred while operating the car. This is a very easy example of strict liability. The sphere of risk is the operation of the car. And these rules are very important for AI systems as well. The last aspect of the conceptual framework of liability certainly is to whom the liability is addressed. In the current discussion, there seems to be a trend on introducing new rules on strict liability of the operator of an AI system. So the basic idea is that the person being obliged to compensate for damages should be the operator of an AI system. Regarding the producer of the AI system, many authors and legislators refer to the existing framework of product liability. And that's why product liability is so interesting for our questions, since this is, at this moment at least, dedicated as serving also to or dealing with the challenges posed by AI systems. The legal framework of product liability is different, obviously, in all jurisdictions. In particular, US law played a very important role in the development of product liability rules. However, in my presentation, as I'm European and in particular German lawyer, I would like to refer to the system of the European product liability, which is applicable all in the European Union and is similarly known by the basic concepts in many other jurisdictions worldwide. The basic rule of the product liability directive is set forth in this Article 1. The producer shall be liable for damage caused by a defect in his product. So there's liability for any damage caused by the product if and only if the product is defective. So the defect of a product is the main reason or source of liability. Please keep this in mind. I will come back to this in a minute. Now, the question is, how can we apply product liability directive to AI systems? It goes without saying, and is not disputed at all, that cyber physical systems, which is a functional unit of hardware and software like self-driving cars, robots, and so ever, are products within the meaning of the product liability directive. It is still somehow disputed, or there's still some uncertainty as to the question in how far software which you can download from the internet can be considered as a product within the product liability directive. Most authors nowadays consider software being a product, and we expect an amendment of the product liability directive, which is announced for next year, which will probably expressly include software into the regime of product liability. This is an important step, as for the past 30 or 40 years, many people were thinking product is never error-free, so software should not be subject to strict liability, but that is state of, or will be probably be state of the art within a few years from now on. When it comes to AI systems and in particular systems which use machine learning to develop their function, the question arises in how far a neural network, or let's say the functional unit of a neural network and the software to run it, can be considered as a product. But obviously, if software is a product, also the functional unit of software and the data model has to be considered as a product. For this reason, all kinds of AI systems which are in place will be subject to product liability under the European scheme. The next question is, who is the producer? Who is the addressee of liability? And this is the producer of the AI system, according to Article 3 of the PLD, as we call it. The producer is, addressee of liability is the producer of the finished product, but also the producer of any raw material or of a component. So if software is a product, in most cases a component, this programmer of such software will be producer and can be liable under the PLD. In the case of a neural network, which gathers its abilities or functions by training, as we know, the person who is conducting that training has to be considered as a producer for the simple reason that the neural network only acquires its functions or abilities via the training, and the training process, which is initiated or steered or conducted by a person, that has to be the producer. To sum up, we don't have any difficulty in applying the PLD on AI systems, including systems which are based on machine learning, and we don't have any difficulty to make liable any person who is responsible for the functionality of such system or software. Now I would turn to the most difficult question in my view with regard to AI systems and product liability. As I said in the first part of my presentations, AI systems have the characteristic that they can show what I would like to call conduct or behavior. In this way, they're different from traditional products. A defect is defined as an insufficient property of a system. So we have to refer to the properties of the system and check if they are fulfilling the expectations or not. Insofar they are below the reasonable safety expectations, the product is to be considered as defective. So in the case, however, how can we apply that systems to an AI systems? Again, the self-driving car offers a simple example. If a self-driving car is running flawless for 1 million of kilometers or even miles, is it defective if it causes an accident in the 1 million and first mile? This example makes it clear, in my view, that conduct or behavior of a system is not per se a property of the system. We should and have to distinguish between property and conduct. However, a kind of bridge between conduct and property can be established if we assume that the ability to behave in a certain way in a given situation can be considered as a property of the AI system. So the property, which is the reference point for defectiveness, is the ability of the system to behave in a certain way.
5 more minutes, Mr. Borges.
Excuse me?
5 more minutes.
That's exactly what I expected. Thank you so much. So product, just to make it short, is not a liability for faulty behavior. And this is important since you have to establish this ability. The next question, and in my view, most difficult question, is what is the reference point for the conduct? If you refer to the ability to conduct or behave in a certain way, what is the reference? Is it human behavior? So far, the legal framework doesn't offer any answer to this, since the legal rules were designed for humans, not for machines. Certainly, human capability can serve as a first orientation for safety expectations to AI systems. You should certainly expect that a self-driving car would behave similarly than a human driver, if, for example, would respect traffic signals or so. However, obviously, there's no limitation by the expectations are not limited by the reference of human capabilities. You definitely can expect a self-driving car to use the brakes much faster with a faster reaction than a human driver. It makes it clear that we need a kind of independent expectations for machine, which are designed to the capabilities of machines and not just apply the rules which have been designed for humans. And the next question is, what is the accuracy? In this conference, as in general, when we develop AI systems, we are proud of accuracy of our tools. But what is the accuracy which we have to expect from an AI system? Can we expect an error-free AI system? Can we expect that it will always, in any future situation, behave correctly? Is that the test? Is it 100% error-freeness what we have to demand? Certainly not, as this would be a liability for behavior, not for an ability. That makes it clear that we have to find out what the fault tolerance in case of an AI systems is, and it's obvious that this depends very much on the risks associated with such systems. You would probably expect a higher accuracy from an airplane or self-driving car than from an AI system which is supporting a lawyer in searching decisions or arguments. And the next question, the next challenge then is, how can we assess that the system fulfills the safety equations, the error, the required accuracy? And this goes via testing. That's why testing of AI systems play a major role in the concepts of liability for AI systems in the future. Proper testing can also be a safety expectation of the product itself under the PLD already. So even if you apply the common, the present legal system, testing can be part of it. The last point I want to mention is the most important one in practice very often, that's the burden of proof. Under the PLD, the injured person shall be required to prove the damage, the defect, and the causal relationship. So the burden of proof is on the victim. Under most legal systems in Europe, we don't have any tools to support the victim in collecting the facts. And even if we had some kind of pre-trial discovery, it is very difficult to establish the fact. For this reason, the expert group, which I mentioned earlier, is suggesting the shift of a burden of proof and say it in certain situations. The expert group did not clarify under which circumstances such shift of a burden of proof should be in place. So the crucial question then is, what are the conditions for such reversal of the burden of proof? I would like to suggest a solution which I described in my paper, which is that the reversal of the burden of proof for defectiveness of a product should be in place in the case of faulty behavior of such product. So once we can establish that the AI system behaved in a given situation in a wrong way, the reversal of the burden of proof that the product as such is not defective shall be on the producer. To conclude, product liability can in general be applied to AI systems. One of the main challenges is what is to distinguish between conduct or behavior on the one side and the property of the system on the other side. However, we can bridge this by considering the ability to behave in a certain way as a property. There are two main challenges in my view. The one is the definition of the expectations regarding the accuracy of an AI system to behave properly. And the other one is the proof of a defect, the burden of proof of a defect. And here I would like to suggest to introduce a shift of the burden of proof for defectiveness in the case of faulty behavior. And that's it. Thank you very much for your attention.
Thank you so much, Mr. Borges, for your presence here tonight and for presenting such a relevant and interesting work. I have two questions from the audience. The first one is from Anna Lauren, and she'd like to know, how could we deal with different levels of autonomy of AI systems? For example, there are many different levels of autonomy of autonomous vehicles. Should the legislator take this into account when creating rules on civil liability for damages?
Oh, that's a nice question, though a very tough one. It's difficult I have to go into much detail to properly answer to it, but let me cut it to a short answer. Yes and no. In case of rules like the Product Liability Directive, which is very broad and has a general clause like notions such as product and defect, specific reference to level of autonomy is not necessary. Judge will specify. In other cases, however, such as specific liability rules for specific products or specific fields should take into consideration the risks, as the legislator should always considering a risk follow a risk-based approach, and usually a higher level of autonomy would involve higher risks. In my previous research, just to give an example, I suggested the introduction of a specific producer's liability for autonomous cars level 4 and 5, however, not for level 1 to 3. So in some cases, it's important to distinguish between the different levels of autonomy. In other rule designs, it's not.
Thank you. I have a second question from Adam Weiner. He'd like to know if you can please comment on the impact of the legal changes you mentioned on software developers and companies.
Who am I to predict the future? That's really difficult, Adam. But I try to do my best. In the past, at least in Germany, and as to my knowledge in many other European jurisdictions, we didn't have much cases on product liability for software, actually, since it was debated if product liability would apply to software at all. In the future, we might see some cases. I don't expect a huge wave of claims against software producers, even though in some cases, just remember the very tragic case of the Boeing 737, that the software with a defect caused tremendously damages. That might be the case. In most cases, however, software will be embedded and the producer of the finished product will be the one who is be the addressee of any claim. And usually the software developer or the software producer will be in a contractual relationship with the producer of the finished product. So in most cases, probably that will be dealt in that way. If more specific legislation will be introduced by the legislator, of course, that may change the game. But just the recognition that software and on the total is part of the software. Part of the product liability scheme. I don't see much changes in the meaning of very important liability risk for software developers.
Thank you, Mr. Borges. We don't have any more questions, but is there any point you'd like to address? Any further comments you'd like to make?
Not really, except for thanking the organizers of ICAIL 21 for this very perfect organization. Thank you very much. also for your interest in my presentation.
Thank you so much. We're now closing the 6th panel of the 4th day of the event, and this is the last panel of the 18th ICAIL. Tomorrow, we'll have a doctoral consortium at 7:30 a.m. GMT and workshops during the day. At 2:30 p.m. GMT, we'll have the awards and closing speeches. On behalf of the ICAIL organization, I'd like to thank everyone in the audience for being here with us tonight, and especially the speakers for also being here with us. And I wish everyone a very good night and see you tomorrow.